Hi, and welcome to this latest immigration law update video. This is the 7th video in my series looking at the Upper Tribunal reported decisions for 2020. And in this video, I'm going to look at the reported decisions for July of this year. There are only 3 decisions, one looking at errors in permission to appeal decisions, one looking at the status of foreign nationality law and passports, and another looking at unlawful removals from the United Kingdom. So let's get going. The first one is the case of Ali and is in relation to errors in permission to appeal decisions by the tribunal and the use of the slip rules. So this applies both to Rule 31 of the first tier tribunal rule and Rule 42 of the upper tribunal procedure rules. The facts of this case, it concerns a student. He'd had a previous appeal in relation to a 60-day letter. The upper tribunal had found that there was an error and that the Home Office should issue him with a new 60-day letter. There was a long delay. Finally, the respondent did issue him with a 60-day letter. Also at that time said, well, you've got to get a new English language certificate because we think you've cheated in your TOEIC test. He was unable to get a new English language test. He was unable to get a new student, a new university sponsor. So he made a human rights application. That was refused. The Home Office relied on the ETS allegation. On appeal, the Home Office withdrew the ETS allegation, but the judge refused the Article 8 appeal. The appellant appealed to the upper tribunal, and the first tier tribunal issued a permission to appeal decision which said at the top, permission is granted on the decision section, but in the reasons for decision, it was clear that the judge meant to refuse permission. So the case came before the upper tribunal and a presidential panel of the upper tribunal in order to give guidance on this issue when there are errors in permission to appeal decisions. So at head note 1, you'll see that the 2 slip rules, Rule 31 in the first tier rules and 42 in the upper tribunal rules, can be employed to correct an error granting or refusing permission to appeal to the upper tribunal. And in a case of an obvious error, the upper tribunal can be expected to proceed as follows. So where the first tier tribunal judge has granted permission, head note 2, but the reasons make it obvious, evident that they meant to refuse, an upper tribunal judge, acting as a judge of the first tier tribunal, will make the necessary correction under Rule 31 of the first tier rules as soon as the matter is identified, whether at the case management stage or later. Now, it should be identified in a Rule 24 response from whoever the respondent is in the appeal, but it's preferable that it's addressed at an earlier stage. 3, where the first tier tribunal judge refuses permission but clearly meant to grant it, any renewal of the permission application before the upper tribunal should point out that error, and you should ask the upper tribunal to correct it under Rule 31 of the first tier tribunal procedure rules. 4, in the upper tribunal, where a judge grants permission when they clearly meant to refuse, the error is unlikely to be identified at the case management stage, especially when that's undertaken by the same judge who mistakenly granted permission. And the tribunal here point out the decision in Ishufaj, where they emphasize the responsibility of a judge dealing with the permission to appeal application to make sure there's no contradiction between their decision and the reasons for it. Where an upper tribunal judge refuses permission to appeal when they meant to grant it, that's an excluded decision, so you can't then appeal up to the appellate court. You should apply to the upper tribunal to use its power under Rule 42. Now, the constant theme throughout this head note is where there is a clear and obvious contradiction. So they say in paragraph 6 of the head note, this applies to clear and obvious contradictions. It says in any other case, parties should proceed on the basis that the decision is that recorded in the relevant document and the tribunal is likely to regard it as productive of delay and a waste of its resources to engage in an inter-parties process in order to determine whether the slip rule should be applied. So this only applies to clear and obvious contradictions. The upper tribunal in this case did go on to consider the error of law and found that the first tier tribunal had made an error of law in not properly considering the effect of the respondent's inaction in this case and the way the respondent prevented the appellant from continuing his course of studies. However, they found that this error of law was not material to the outcome because the appellant had suffered actually no material prejudice. They do, by the way, it's not in the headnote, but they do review a bit of the authorities on the interrelationship between the ability to pursue studies and articulate, and they look at old cases like CDS and Patel. Have a look at what President Lane says at paragraph 71. The respondent's administrative failings are very unlikely to result in a decision being disproportionate where it's prevented somebody from continuing a course of studies, but it may unusually reduce the weight to be given to the public interest. Have a look at paragraph 71. The second case is a decision of Deputy President Ockleton in Hussein and another, and it's looking at the status of passports and foreign law. This was a case where there had been an appeal by the appellant and his son. The appellant also had his wife and other children as dependents. The son was over 18, so he was a separate appellant before the first tier tribunal. In relation to Dad, the first tier tribunal dismissed the appeal and found that he was not credible and found that he was a national of Tanzania. Some different considerations to the son, who was a national of Kenya, and there's some other issues in his appeal. His appeal was also dismissed. An application for permission to appeal came before the first tier tribunal, and again, comments about permission to appeal decisions, because Judge Ockleton is critical of the permission to appeal decision and said the reasons are unintelligible. In fact, the father, the appellant, was granted permission to appeal. The son was refused permission to appeal, although Judge Ockleton does grant him permission to appeal in the judgment, but ultimately dismisses the appeal of both of them. The father had a Tanzanian passport. It was his second passport. In fact, it had been renewed. He traveled on it lots, including visiting the United Kingdom. But it was his claim that he was, in fact, a Somali national and his Tanzanian passport was not genuine. And with the permission to appeal application, various Tanzanian statutes were produced, and it was argued that under Tanzanian law, he was not a national. Judge Ockleton finds that a person who holds a genuine passport apparently issued to him and not falsified or altered has to be regarded as a national of the state that issued the passport. Have a look at paragraphs, I think it's 11 to 13 of the judgment, which looks at the status of genuine passports. The burden of proving the contrary lies on the claimant in an asylum case. And then in the important part, foreign law, including nationality law, is a matter of evidence to be proved by expert evidence directed specifically to the point in issue. So if you're going to rely on foreign law, you can't just produce various statutes and say, well, hang about, I'm not a national of Tanzania. You've got to produce expert evidence. And Judge Ockleton relies on the decision of President McCluskey in the CS case from 2017 and his own decision sitting as a deputy high court judge in MK, which was the statelessness case. So foreign law is a matter of evidence, and you're going to need expert evidence to establish it. All right, let's move to the final case, and that's a case called L, and is about unlawful removals from the United Kingdom. L was is a Nigerian national. He'd previously been married to an Italian national, and they'd had some children, but this concerns his fresh claim for asylum. His fresh claim for asylum was based on being bisexual and converting to Christianity. Now, that was accepted as a fresh claim, and that's going to be important. So 353 was accepted as being satisfied. So it was satisfied that by the respondent that there was a realistic prospect of success, but they refused to grant him asylum. So he appealed. Now, he attended a case management review hearing where he provided a new address, and that was noted down, I think, by the presenting officer and on the court file. But when it came to the appeal, notice was sent to the wrong address, and a judge proceeded wrongly to determine the appeal in his absence. And the determination was sent to the wrong old address. He applied for permission to appeal. Now, it was thought that that was an out-of-time application, but it wasn't, in fact, because he hadn't properly been served the earlier decision. Ultimately, he was granted permission to appeal, and the upper tribunal remitted his appeal for a hearing before the first-tier tribunal. Before he was granted permission to appeal, he was in fact removed from the United Kingdom by the Home Office. Now, importantly, the President, Mr. Justice Lane, cites some file minutes from the Home Office because they sought internal guidance, and their own internal guidance said, well, we shouldn't remove him at the moment because it seems there's merit in his application for permission to appeal, that he had informed of the new address, that it shouldn't have been pursued in his absence, the appeal, and it looks like the determination was sent to the wrong address, so they would have known that the application probably wasn't out of time. The Secretary of State ignored their own advice. They wrote to the tribunal and said, well, can you determine this this out-of-time permission to appeal application as soon as possible because we want to remove him? The tribunal just wrote back saying, well, an out-of-time application is no bar to removal, so the Secretary of State went ahead and removed him. His appeal, as I said, was remitted to the first-tier tribunal. The first-tier tribunal decided it didn't have the power to order his return to the United Kingdom, so judicial review proceedings were launched. And in this case, the President decided as follows: a decision to remove a person from the United Kingdom under immigration powers will not be unlawful by reason of the fact that it is predicated upon an earlier decision which has not at the time of removal been found to be unlawful, but is later so found. So if you remove somebody and there's been a decision that later after removal is found unlawful, that means the removal wasn't unlawful. But the fact that the removal too was not unlawful will not necessarily preclude a court or tribunal on JR from ordering P's return. But the fact it was a lawful removal is a highly material factor in the exercise of discretion. 3, where, however, the claimant's removal was unlawful by reference to the position at the time of the removal, the fact should not only constitute the starting point for the tribunal's consideration of the exercise of its discretion to order return, but is also likely to be a weighty factor in favour of making such an order. The same is true with the effect of P's removal has been to deprive P of an in-country right of appeal. And the President of the Upper Tribunal here finds that in this case, the applicant's removal was unlawful. The Secretary of State should have known of the fact, and it was clear from their own internal guidance about that. And he'd been deprived of a proper in-country right of appeal because they'd accepted that the fresh claim test was met and there was a realistic prospect of success. The Secretary of State tried to argue there were other reasons because of his conduct, but that was rejected by the President, and they found removal was unlawful and that an order should be made for the respondent to use their best endeavours to return him to the United Kingdom. The end of the judgment, in fact, goes through the effect of COVID on whether they should make an order or not. The Secretary of State argued that because of COVID, an order shouldn't be made for him to return to the United Kingdom and that the appeal should be conducted by remote means from abroad. But ultimately, the President rejected that and found, notwithstanding COVID, he should still make the order for the applicant to be returned to the United Kingdom. So an important case there on unlawful removals. So those are the 3 decisions for July 2020. I hope that's helpful to you. As usual, I'll put the slides on Number 8's website, and the links to the case law will be in the description below this video on YouTube. Thanks a lot. I hope to be back with you soon when we'll look at the decisions for August 2020.